found that if the presence of members of parliament and representatives of the national executive in the county development boards was merely to contribute by way of public participation in matters affecting counties, there would be no concern. However, in its assessment, the court found that the proposed amendments donated excessive powers to the board beyond what the Constitution permits and thereby subordinated the county organs. And we stated in that case that the two levels must embrace the devolution architecture by displaying collaborative coexistence and interdependence so as to avoid any possible constitutional discord. At all times, we emphasize this arrangement must maintain a balanced structure where national government does not usurp, undermine, or interfere with the mandate of or with matters which exclusively fall within the domain of county governments. The Supreme Court was emphatic that the independence between devolution institutions must be maintained. On the proposed mandate of the County Development Board, the court stated as follows: the Senate is not expected to relocate to the counties to exercise supervisory powers at that level. That would be intrusive into the functional and institutional integrity of the county government and a totally unacceptable overreach. It must not be involved in the administrative nitty-gritty details of the counties. The Senate must stay where the Constitution puts it, and its oversight, as indeed its legislative roles, are to be exercised in accordance with the Constitution and the law. The Supreme Court also clarified the roles between senators and governors through considering the proposal for the county senator to chair the County Development Board and deputized by the county governor. We say it as follows. And here, doesn't it cross your mind that Parliament had the CDF at some stage chaired by members of Parliament? Was this not an attempt to replicate that? But this is what the Supreme Court said. The Constitution does not contemplate a situation where the chief executives of the counties, to wit the governors, are inferior in rank to senators in the execution of county functions. For this reason, Section 91A1A and D was found to not obey the Constitution. And in particular, Article 179, sub-article 1, 5, and 6, to the extent that their attempted amendment altered the hierarchical structure of the county government. It is inconceivable, as it is absurd, to have a senator whose functions are clearly delineated by the Constitution and who is expected to provide oversight over the county government to at the same time take charge of a board which is essentially a county organ. That's what the Supreme Court found. This is legislative overreach, and it does not honor the constitutional guardrails that donate specific and distinct powers to the Senate and to the devolved units. And so the amendment, in purporting to impose on the governor a principle, fails to meet the test of cooperation, coordination, and consultation. It fails to respect the functional and institutional integrity of the county government, its institutions, and its constitutional status as stipulated in Article 189 of the Constitution, with the consequence that we threw that out. One of the early cases in which the Supreme Court provided clarity in the relationship between the two levels of government was in the Speaker of the Senate and another versus the Attorney General and another. In this matter, the Speaker of the Senate sought an advisory opinion on the role of the National Assembly vis-a-vis the Senate in the origination, consideration, and enactment of the division and allocation of revenue bills by a majority. This is what this court held. It is clear to us that the Senate had a clear role to play in the processing of the division of revenue bill. The Speaker of the National Assembly should have complied with the terms of Article 112 of the Constitution, and the National Assembly should have considered the deliberations of the Senate on the record, and failing concurrence on legislative choices, the matter should have been brought before a mediation committee in accordance with the terms of Article 113 of the Constitution. Am I reminding somebody of something that was happening not too long ago? Do you follow the proceedings in Parliament? We'll see that in a minute. This matter was again canvassed by the Supreme Court over 5 years later, when another impasse arose on the division of the revenue bill between the National Assembly and the Senate. Once again, the Supreme Court was approached to proffer an advisory opinion on, among other things, the effect of a failure between the Senate and the National Assembly to agree on a division of revenue bill. This was in the case of the matter of the Council of Governors and 47 others. The Supreme Court advised as follows: that should an impasse occur due to the failure of the mediation process, occasioned by the lack of concurrence between the two houses over the division of revenue bill, the National Assembly shall, for the purpose of meeting the expenditure necessary to carry on the services of the county government during that year, until such time as the Division of Revenue Act is assented to, authorize withdrawal of money from the consolidated fund to enable the running of the county unit. The money so withdrawn shall be included under separate votes for the several services in respect of which they were withdrawn. That's what the Supreme Court found: accountability. The Supreme Court has also provided clarity and guidance on the constitutional oversight roles of the Senate and county assemblies over county governments. In the matter of in Senate versus Council of County Governors and 6 others, the court found that the Senate is constitutionally mandated to summon county governors in exercise of its oversight role pursuant to Article 96(3) of the Constitution, and that the oversight role of both the Senate and the County Assembly is not limited to the county's nationally allocated revenue or locally generated revenue, respectively. And the court found as follows: the foregoing constitutional provisions, as read together with the Articles 110 to 112, leave no doubt that the Senate is established to perform fundamental roles of governance concerning counties. These are legislative, budgetary, and oversight. It has been granted considerable latitude in ensuring that county governments operate at optimal and within accountability standards if the objectives of devolution are to be realized. There's no way by which the Senate can perform such an important role without having the powers to summon a governor and to require him or her to provide answers and offer explanations regarding the management of county finances and related affairs. Without such power, the Senate would not be able to protect the interests of counties, nor would it be able to exercise effective oversight of national revenue allocated to counties. Further to that, the court emphasized that the purpose of the Constitution is to entrench good governance, the rule of law, accountability, transparency, and prudent management of public finances at both levels of government, and such grand purpose cannot be served if either the Senate or county assemblies begin to develop centers of oversight or influence within themselves. The court thus identified the county assemblies as providing the first tier of oversight, while the Senate provided the second and the final tier of oversight. I need to mention here that these cases, I've given you the citations, the years when we had them, were in the very early days of devolution. We are starting the process of devolution from the 2010 Constitution. Things have somewhat settled down, and we don't find too much resistance, or am I also crossing the line there, from governors attending to Senate when they are called to account. The manner of election, appointment, and removal of county officials is central to the institutional independence of these entities. Through the determination of election petitions, the Supreme Court has strengthened the electoral system, thereby ensuring that senators and governors are duly elected to serve. The Supreme Court has had opportunity to provide lucidity on matters concerning institutional independence, separation of powers, when considering the impeachment of a governor via a decision of a county assembly and the Senate. Please tell me, that case that I'm just about to talk about, not the teachers. What is this case? There was a governor in this republic who served their entire term under the process of impeachment. What case is this? What case? You want me to ask Professor Kivuda? It wasn't he. For him, he nearly dissolved his. This is in the case of Justice Kariuki Mate and another versus Martin Nyaga Pambora, emphasizing that by the doctrine of separation of powers, the limits of judicial authority and the Constitution's design of entrusting certain issues to other organs of government are vital principles. The Supreme Court reasserted its previous decision in the matter of the Judicial Service Commission versus the Speaker of the National Assembly and 8 others, where it had stated, as I quote, "The Constitution disperses powers among various constitutional organs, where it is alleged that at any of these organs, organs has failed to act in accordance with the Constitution, then the courts are empowered by Article 165, Subarticle 3D2, to determine whether anything said to be done under the authority of the Constitution or of any law is inconsistent with or in contravention of the Constitution. The court developed a number of principles relating to the separation of powers, which we did up to just the other day. We don't get involved in the impeachment processes that the Constitution has given power to another arm of government to deal with. And so we said the following, or set out the following principles. Each arm of government has an obligation to recognize the independence of other arms of government. Each arm of government is under duty to refrain from directing another organ on how to exercise its mandate. The courts of law are the proper judge of compliance with constitutional edict for all public agencies, but this is attended with the duty of objectivity and specificity in the exercise of a judgment. For the due functioning of constitutional governance, the courts must be guided by restraint, limiting themselves to intervention in requisite instances upon appreciating the prevailing circumstances and the objective needs and public interests attending each case, and in the performance of the respective functions, every arm of government is subject to the law. The Supreme Court also has settled the question whether a court may interfere with legislation processes that are in actual progress, such as in impeachment of a governor. Recognizing the jurisdiction of the courts whilst urging judicial restraint, the Supreme Court has stated as follows: the County Assembly to have been operating quite properly within the constitutional scheme of devolution and running its legislative processes within the ordinary safeguards of separation of powers, and consequently quite legitimately outside the path of the ordinary motions of the judicial arm of state. On that basis, there would have been hardly any scope for the deployment of the court's conservatory orders. We refused to get involved and did not give any conservatory order in that case. In the famous case of Songo versus the County Assembly of Nairobi City and 11 others, the appellant had challenged his impeachment, questioning whether the due process was followed. The Supreme Court determined that the impeachment proceedings before the County Assembly and Senate were properly conducted in accordance with the Constitution, the County Governments Act, and standing orders of both the Assembly and the Senate. In another case, in the Speaker and the County Assembly of Embu, the Speaker of the County Assembly of Embu sought an advisory opinion from the court regarding the process of filling the position of Deputy Governor upon a vacancy arising as a result of the removal of a county governor through impeachment proceedings. The Supreme Court, acknowledging that the existence of a lacuna in law would not be allowed, stated as follows: from the signal embodied in Article 149 of the Constitution, and in the absence of any applicable legislative provision, we hold that where a vacancy occurs in the office of the Deputy Governor, County Governor, the Governor shall, within 14 14 days, nominate a person to fill such vacancy. The County Assembly shall vote on the nomination within 60 days after receiving it. Where a vacancy occurs in both the offices of the county governor and the county deputy governor at the same time, the office of the deputy governor shall remain vacant until the election of a new governor. And that's because it is the governor that nominates the deputy governor. The new governor shall nominate a person to fill the vacancy within 14 days after assuming office. The county assembly shall then vote on the nomination within 60 days after receiving it. And for the avoidance of doubt, we hereby state that this holding shall obtain in all circumstances pursuant to which the office of the deputy governor may become vacant as contemplated by the Constitution, that is to say, either by way of death, resignation, or impeachment. That decision formed the basis for the enactment of a statutory process for filling a vacancy in the office of the deputy governor. The Supreme Court has also provided guidance on the participation of the Senate in the lawmaking function of Parliament by considering, debating, and approving bills concerning counties. In the matter of Institute for Social Accountability and Another versus the National Assembly and others, the court held that the Constituency Development Fund Act and the Constituency Development Fund Amendment Act 2013 concerned county governments, and failure to involve the Senate in the enactment process of constitutional. Similarly, that the CDF Act 2013 violated the division of functions between the national and county levels of government for reasons that, under the Constitution, the decentralization of service must be undertaken within the confines of the structures of the National Assembly or county governments, not parallel to the two levels of government. Now, as the above jurisprudence would show, the Supreme Court has played a central and critical role in strengthening the devolution process in this country. The jurisprudence of the court has promoted the purposes, values, and principles of the Constitution, marrying principle with history and the context to ensure outcomes that positively develop the law and have a positive impact at a county and at a national level. There is thread that runs through the court's jurisprudence on devolution that I would say is characterized by 6 markers, and the 6 markers I've already mentioned are as follows: independence, interdependence, social and institutional cohesion, participatory democracy, accountability, and constitutionalism. Returning to the assessment markers I referred to in the introduction, 1, asserting the supremacy of the Constitution and the sovereignty of the people of Kenya, and 2, developing rich jurisprudence that respects Kenya's history and traditions and facilitates its social, economic, and political growth. I would say, without a doubt, that in regard to devolution, the Supreme Court would score very well. Let us then look at the Chapter 15 commissions. As was the case with devolution, the constitutional commissions and independent offices established under Constitution 2010 were a response to a governance context seen as lacking transparency and accountability. Whilst some of the commissions existed under the previous constitutional dispensation, many were largely devoid of any independence in the execution of their duties and were subject to interference and control of the executive. It was strongly felt that there was need for independent bodies that would provide oversight, over, secure the proper functioning of, and effective public service delivery through key state organs, including the judiciary, parliament, and those within the executive. The Chapter 15 commissions and the independent offices were established to provide these crucial functions in a number of key areas seen as historically problematic and crucial to the nation-building project under the 2010 constitutional dispensation. And this included land administration, election regulation, human rights enforcement, salaries in the public sphere, appointments and disciplinary action for the police, for the public service, in the judiciary, in parliament, among teachers, and allocation of county revenue and public finance management. Chapter 15 of the Constitution 2010 anchors the independent offices and constitutional commissions in it. Article 248 identifies the following as the Chapter 15 commissions. They are not, in my view, listed in their order of importance, but they are as follows. The Kenya National Human Rights and Equality Commission, the National Land Commission, the Independent Electoral and Boundaries Commission, the Parliamentary Service Commission, the Judicial Service Commission, the Commission on Revenue Allocation, the Public Service Commission, the Salaries and Remuneration Commission, the Teachers Service Commission, and the National Police Service Commission. That article further identifies the two independent offices, and the two independent offices are those of the Auditor General and that of the Controller of Budget. The objectives of these commissions and independent offices are threefold. They are to protect the sovereignty of the people, to secure the observance by all state organs of democratic values and principles, and to promote constitutionalism. The independence of the commissions and the holders of independent offices is constitutionally entrenched under Article 249, Subarticle 2 and Subarticle 3, which provide that they are subject only to the Constitution and the law. They are independent and not subject to direction or control by any personal authority, and that Parliament must allocate adequate funds to enable each of these commissions and independent offices to perform their functions. Now, decisions from the Supreme Court have recognized the importance of these commissions and independent offices and ensured their autonomy and independence, and strengthened their ability to undertake their respective functions in the manner envisaged under the Constitution. We have above discussed how the Supreme Court developed the principles of devolution and clarified the court's exclusive jurisdiction to issue advisory opinions as sought by state organs in matters related to county governments. And you remember, in the matter of the independence, in the matter of the interim independent Electoral Commission is where we set out those principles. Now, flowing from there, in this seminal one, the court also elucidated in detail on the institutional independence of Chapter 15 commissions and independent officers. I'll be referring to that Independent Electoral Commission case. This was in regard to the provision in the Supreme Court rules that requires that before a reference for an advisory opinion can be sought, if the matter, in the opinion of the court, can be resolved by the advice of the Attorney General, then such advice must and should first be sought. It was argued that in regard to the then interim Independent Electoral Commission, such a requirement was unconstitutional as it interfered with the independence of a constitutional commission. This is what the Supreme Court found. Quote, the real purpose of the independent clause with regard to commissions and independent offices established under the Constitution was to provide a safeguard against undue influence with such commissions or offices, undue interference with such commissions or offices by other persons or other institutions of government. Such a provision was incorporated in the Constitution as an antidote in the light of regrettable memories of an all-powerful presidency that since independence in 1963 had emasculated other arms of government, even as it irreparably trespassed upon the fundamental rights and freedoms of the individual. The Constitution established the several independent commissions alongside the judicial branch, entrusting to them special governance mandates of critical importance in the new dispensation. They are the custodians of the fundamental ingredients of democracy, such as the rule of law, integrity, transparency, human rights, and public participation. The several independent commissions and offices are intended to serve as the people's watchman, the people's watchdog. And to perform this role effectively, they must operate without improper influences, without fear of favor. This indeed is the purpose of the Independence Clause. While bearing in mind that various commissions and independent offices are required to function free of subjection to direction or control by any person or authority, the court held that this expression is to be accorded its ordinary and natural meaning, and it means that the commissions and independent offices, in carrying out their functions, are not to take orders or instructions from organs or persons outside their ambit. So independent officers must, however, operate within the terms of the Constitution and the law. The Independence Clause does not accord them a carte blanche to act or conduct themselves on whim. Their independence is by design configured to the execution of their mandate and performance of their functions as prescribed in the Constitution and the law. For due operation in the matrix, independence does not mean detachment. That's what the Supreme Court found. And it does not mean isolation. It most definitely does not mean disengagement from other players in public governance. Indeed, for practical purposes, an independent commission will often find it necessary to coordinate and harmonize its activities with those of other institutions of government or other commissions so as to maximize results in public interest. Constant consultation and coordination with other organs of government and with civil society as may be necessary will ensure a seamless and an efficient and effective rendering of service to the people in whose name the Constitution has instituted the safeguards in question. The moral of this recognition is that commissions and independent officers are not to plead independence as an end in itself, for public governance tasks are apt to be severely strained by possible clashes of independence. What is being promoted there is not just independence, but interdependence, and consultation, what we sometimes call benchmarking. I don't know what it is called in the judicial language. This position was also articulated by the Supreme Court in the matter of the Communications Commission of Kenya and 5 others versus the Royal Media Services Limited and 5 others, where we stated as follows: independence is a shield against influence or interference from external forces. In this case, such forces are the government, political interests, and commercial interests. The body in question must be seen to be carrying out its functions free of orders, instructions, or any other instructions from those forces, intrusions. The body in question must be seen to be carrying out its functions free of orders, instructions, or any other intrusions from other forces. However, such a body cannot disengage from other players in public governance. How is the shield of independence to be attained then? In a number of ways. The main safeguard is the Constitution, and the other is the law. Once the law, more so the Constitution, decrees that such a body shall operate independently, then any attempt by any other forces to interfere with such an independent execution of mandate must be resisted on the basis of what the law says. Operationally, however, it may be necessary to put other safeguards in place in order to attain independence in reality. Such safeguards could range from the manner in which members of the said bodies are appointed to the operational procedures of the body and even the composition of the body. However, none of these other safeguards can singly guarantee independence. It takes a combination of this and the fortitude of the men and women who occupy office in the said body to attain independence. In the National Land Commission versus the Attorney General and 5 others, the Supreme Court further detailed the elements of such independence. The first, functional administrative independence. And this entails commissions exercising their autonomy through carrying out their functions without receiving any instructions or orders from other state organs or bodies. 2, operational independence. This includes functional independence, and it is a safeguard or shield for independence manifested through the procedure of appointments of commissioners, the composition of the commission, and the procedures of the commission, Article 255, Subarticle 1G of the Constitution provides an elaborate procedure for the amendment of the Constitution in matters dealing with the independence of the judiciary, as well as commissions and independent officers, to which Chapter 15 of the Constitution applies. 3, there is financial independence, which means that a commission has the autonomy to access funds which it reasonably requires for the conduct of its functions. However, according to Article 249, Subarticle 3 of the Constitution, Parliament is the one mandated to set for the Commission the budget considered adequate for its functions. Perception of independence. This must mean that the commissions must be seen to be carrying out their functions free from external interferences. Collaboration and consultation with other state organs. Independence of commissions and independent officers does not, by any chance, entail a splendid isolation from other state organs. For example, Article 249, Subarticle 1 of the Constitution expressly entrusts the National Land Commission with the duty to protect the sovereignty of the people, secure the observance by the state organs of the democratic values and principles, and to promote constitutionalism. The crux of these decisions is to emphasize the independence of commissions and independent officers, whilst at the same time recognizing their accountability and interdependence with other state organs within the constitutional design. Article 249, Subarticle 1 of the Constitution signals the checks that the commissions have on other arms of government, whilst simultaneously Article 254 provides for the accountability of these independent entities to the executive and to the legislature. Article 2541 requires commissions to file annual reports to the President and to Parliament, and by Article 254, Subarticle 2, the President and the National Assembly may require a commission to submit a report on a particular issue. The Supreme Court, in the case of the Kenya Vision 2030 Delivery Board and versus the Commission on Administrative Justice and two others, emphasized that commissions are supposed to act as watchdogs and cooperate and work with government arms. It also reasserted the duty of Parliament to implement reports from commissions pursuant to Article 254, Subarticle 1 of the Constitution. It, however, held that commissions cannot implement their own recommendations nor force a recommendation on a public body lest they usurp the role of the organ vested with the mandate to enforce implementation. The court further developed guidelines and guiding principles to assist courts when considering matters concerning the binding nature of recommendations from commissions. These are as follows. 1, any power to make a recommendation ought to be specifically provided for in the Constitution or in the law. 2, the recommendations do not necessarily bind the person to whom or entity to which it is addressed. 3, a recommendation from a commission is only binding upon a public entity where it has been specifically provided for in the Constitution or in the law. And 4, the manner in which a recommendation is to be implemented by a public entity is discretionary. 5, exercise of discretion in implementing a recommendation may only be interfered with where there is gross abuse of discretion, manifest injustice, or palpable excess of authority. 6, any recommendation by a commission which is not implemented may be reported to Parliament for any further action. if that be necessary. In the matter of the Council of Governors and 47 others, the Supreme Court considered whether the recommendations of the Commission on Revenue Allocation were binding on both the Senate and the National Assembly when they deliberated on the Division of Revenue Bill and the Appropriation Bill. And the Supreme Court emphasized the importance of place in the Constitution places in Chapter 15 commissions. It asserted that in the instant case, the Constitution placed a very high premium on the recommendations by the Commission for Revenue Allocation, and such recommendations, once tabled in Parliament, must be accorded due consideration before a vote is taken by either of the houses on the Division of Revenue Bill and the County Allocation of Revenue Bill, while stating that if either of the two houses passed a bill under Article 205 without considering the recommendations of the Commission, the resultant legislation would be unconstitutional. The Court nevertheless found that recommendations by the Commission on Revenue Allocation were not binding upon either the National Assembly or the Senate. You must have heard that lately. The Court stated, or something similar, the Court stated that to opine otherwise would be, quote, to elevate the Commission above Parliament in the legislative chain, and it could not have been the intention of the makers of the Constitution to supplant the legislative authority of Parliament in matters finance by establishing the Commission on Revenue Allocation. The Court went further to state that not every deviation from the Commission's recommendations is to be explained away in a memorandum, only a significant deviation. What constitutes a significant deviation is a matter to be determined by the courts on a case-to-case basis. The Supreme Court's jurisprudence on the subject emphasizes the indispensable and important role of constitutional commissions and independent officers in upholding democratic governance and the rule of law. The Court has unequivocally asserted their independence, stating that these entities must function free from external influence, thereby ensuring impartiality in their operations. By safeguarding the autonomy of these commissions and independent officers, the Supreme Court not only reinforces their effective functioning, but also strengthens the framework of accountability within the government. This commitment to independence is vital for maintaining public trust in democratic institutions, as it ensures that these bodies can carry out their mandates without fear of repression or fear of interference. These two subjects are difficult and they are not exciting. But they are critically important, so let's bring them to an end. It is clear that our Supreme Court has asserted the institutional independence of Chapter 15 commissions and independent officers whilst placing them within the wider framework of transparency, accountability, and mutual interdependence with other state organs within our constitutional architecture. At the beginning, I placed two important parameters through which the substantive effectiveness of the Supreme Court's jurisprudence can be assessed. Given the key highlights I have laid out above, I now look forward to hearing some of your insights into whether you concur with my positive assessment of the court. I have had occasion to peruse the content and materials in your constitutional theory. LLB 109 course. And considering its breadth and depth, with specific lectures on devolution, I like what Maurice said in the beginning, Chapter 15, Commissions and Independent Offices, Separation of Powers and Constitutionalism, I'm sure you may have a lot to say on the contributions of my court to constitutionalism, with particular focus on the subject area at hand, devolution, commissions, and independent offices. I look forward to the ensuing engagement and feedback. More importantly, thank you very much for having invited us here. The Supreme Court is better for engaging with you and with the other academia, and I cannot emphasize the importance of law students and you, the academia, in improving and securing the effectiveness, not just of the Supreme Court, but the entire edifice of the justice provision. As we commemorate our 12 years of the existence of the court, I hope we can strengthen and expand all avenues of engagement and interaction between law institutions, law in academia, and law in praxis. There's so much to learn and so very much to gain through these interactions. I'm sure our discussions today will have a positive impact on the development of the court and in shaping its future jurisprudence. I await feedback. Thank you very much for listening to me.
Okay, Your Lordship, thank you very much. I concur. And this brings us to the most interactive part of the public lecture, and that is the question and answer session. And I would like to, actually, it's our leadership will take the questions from there, so it's okay. You can return this. You can return them. Sorry for that. Sorry for that confusion. So I have said I have two guidelines. They are not supposed to be intimidative. They are rules of etiquette, and therefore the first guideline is a reminder to all of us, the audience, that we should keep the questions focused and concise. And number two guideline is that please ask questions that help us to maintain the respectful and organized interaction so that we have a successful outcome. And therefore, I have 3 assistants. I don't know where you are. Yeah, come to the front here so that people can see you. When you light a candle, you put it somewhere where people can see it. So one of you here, Kenty, right here. Matthews, you can come to the middle. And Caleb, where are you, Caleb? You go to the other side. You will be looking. So any member of the audience who has a question or comment, keeping it very short, given the guidelines, please raise up your hand and we will give you the opportunity. I expect a lot of participation from the students. If you don't have a question, you can provide a short comment. And I will start you off by saying that these decisions of the Supreme Court and certain leading decisions of the High Court since the promulgation of the Constitution in 2010 have been very helpful to us as lecturers. I have particularly used them to introduce law to students in the University of Nairobi and Daystar on legal systems and methods, and some of them are here. And they have really helped us to usher in the new dispensation in teaching law after the promulgation of the Constitution. And I will also reflect very briefly on our fears. You will recall that I was one of the commissioners of the Kenya Law Reform Commission when we drafted the Constitution of Kenya 2010. And one of the fears with the people of Kenya was the possibility of devolving corruption, which was a key concern for the promulgation of the new Constitution. So many years down the line, it would be appropriate, although I know the Supreme Court has not had an opportunity to discuss that, scholars are very much interested in assessing the extent to which devolution has controlled corruption in public and even the private sector. So do we have any comments, questions? Yes, thank you so much. I love people who are ready to interact. And I'm looking at the first years also because I'm teaching you the law of contract. We didn't discuss the Constitution, but I mentioned all the time I've been discussing how the Constitution imports into contract law. Yes? You give him the mic, can't you? You will stand up, introduce yourself. You can test the mic or the mic in advance so that we don't waste time. Please test yours, Matthew. Am I the cause? No.
Good afternoon. My name is Alex Kimani, and I have a question. It's based on the Constitution.
You know, I would go a step further and say I am in this year.
That is student.
Yes, very important.
The first semester. If I may continue. The question is based on Constitutional Commission and independent offices. So it is based on the newly introduced bill, which was suggesting the removal of the legislature of the presidential polls. Is it in violation, in any way in contradiction with the independent clause for the operation of the IEBC, now that it brings into violation the public trust of individuals in the IEBC? Thank you.
Thank you very much, Alex. We should take about 3 or 5 questions, then our leadership will take them together. Yes, you have caught my eye at the back. Where is Caleb? Caleb, you have moved from your position. Caleb, it's not working. Okay, we can use the one with Matthew Tanui. And I saw another hand here. You will be next, then you and you, in that order.
Thank you.
We can use one mic, the one which is working. The one with you, yeah, let's use it. It looks like they're not working. So let us not use them. They don't appear to have been tested in advance. We are sorry for that. Yeah. Let's use one mic so that we can move faster. Okay, yes?
Thank you, Your Ladyship. My name is Tony Tonje. I'm a 3.1 student. And my question is in line with the doctrine of separation of powers. When we handle the doctrine of separation of powers, we say the three arms are to stay interdependent while independent. The legislature and the executive, they are watched by the judiciary. And a question arises, who watches the watchdog?
Very good, thank you. Next is in front here. And who is number 4? You, number 5.
Good afternoon, everyone.
Yes.
My name is Churchill Brighton Owoko. I'm a 3.1 student. I have 2 questions. The first one, Deputy Chief Justice, while addressing us, you said that the Supreme Court will not issue an advisory opinion when, according to its own opinion, it sees that the Attorney General can issue an opinion in the same manner. So, in the event that the Attorney General issues an opinion and the parties are not satisfied, are they allowed to appeal to the Supreme Court for a decision? Secondly, you said that the issue of separation of powers, in the issue of separation of powers, in a legislative process, if a party feels like, let's say in the case of an impeachment, the process in which the matter is being handled, the party being impeached is not satisfied, and the party approaches the court, and the court defends itself using the idea of judicial restraint. What is the place of interlocutory reliefs with regards to such a matter? Thank you.
Okay, thank you. And number 4.
Good afternoon. My name is Buki Halkano. I am in 4.2. I appreciate the dispensability from the Deputy Chief Justice. And my question is on the revenue sharing and accountability. The Deputy Chief Justice has mentioned that in its rulings and the cases that she has stated rather, such as in the Council of Governors versus the Attorney General, in addressing the delays that has been there in disbursing funds to the county government. I'd like maybe for her to clarify on how the court has taken the issue of ensuring compliance with this equitable revenue sharing, particularly from the national government, and the need for balancing the fiscal autonomy and ensuring that corruption and financial mismanagement within the county level has been addressed. Thank you.
Thank you, Alkano Buke. The final one down there, then I will ask the Deputy Chief Justice if I should take more questions so that we have only one round of questions because of time. Yes?
So, good afternoon, learned friends and learning friends. All right, so...
You have not yet become learned. You have to await admission as an advocate.
I'm still I'm a learning friend, and the DCJ and the panel in front there are already learned. So my name is Sirwanga Jeff. I'm a second year student. So
that is 2.1.
Yeah.
I met you for legal systems and methods.
Yes, sir.
Carry on.
So I have a question. And I would like this to be answered particularly by the DCJ for clarity. Us being lawyers, we always, we are supposed to like promote justice to the society, right? So what is the judiciary? How does judiciary achieve this now that after many judgments we find that the public has lost faith in the judiciary, especially when judgments always are against the public interest? Like from the recent judgments, we see that a good number from the info track, we see that majority of the public isn't in tandem with the judicial judgments. Like not everybody is supporting the judgments made by the judiciary, and there is this feeling of state capture where the public feel that the executive has captured the judiciary. How does DCJ handle this, and how can we work to regain the faith of the public? Thank you.
Thank you so much. Your Lordship, should I take a few more questions so that you can answer all of them at once, so that we only have one Q&A? Okay, any other? Yes, Kenti?
So my name is Yvonne Kendi, a 3.1 law student. My question is based on the impeachment framework in Kenya. So looking at the gubernatorial impeachment framework and the recent cases that has been decided by the courts, one would like to understand, do we really say that the impeachment framework only exists in theory and not in practice? Can one then say, judging from the decided cases, that this impeachment is used as a tool for bargain? Thank you.
Thank you so much. I thought, Caleb, you would ask questions either on ADR or e-commerce as they relate to today's topic. Are there any other members of the audience with questions? Now raise up your hand, we decide how many we will allow. Raise up. That's 1, 2, 3. I will not count, Professor. I will give you the final. 4, 5, 6, 7, 8. Excluding faculty, we have. Okay, we do the students first. Eh? Okay, but very concise and focused. Yes, give them in that order.
Good afternoon. Good afternoon. I'm Vanessa Haika.
My name is so and so. Carry on.
My name is Vanessa Haika, 4.1 student. And I have a question with regard to the balance between judicial restraint and judicial activism. How do you balance the restraint and activism in basically answering constitutional questions?
Good. Thank you. Next. You saw how I counted. Yes?
My name is Collines Mwilu, 2.1 student. Now, I have a concern regarding recusal of apex court judges. Recently, we had, I think a few weeks ago, Supreme Court judges, DCJ included, who recused themselves from a high-profile case. Now, my concern is, and I think she acknowledged that there might be an appeal. So my concern is, in case of an appeal, what happens since they had recused themselves from that case? And then my other concern, it is out of curiosity. I joined law school last year, and the first person who talked to us was our HOD, Dr. Martin Olo, and he insists you must read. And then he told us, when it comes to judges, you even have to read even more. Huwezi sema chapa ni draw. So for you, DCJ, have you ever met two counsels who have presented their cases so nicely, and you've gone to an extent that you can't choose who is winning, and you say, rock, paper, scissors? Has it ever happened to you? I think, thank you.
Thank you. Thank you so much. These are very sharp questions, and I like them. Carry on.
Good afternoon. My name is Abigail Omondi, and my question to the DCJ is when she said that independence does not mean detachment or isolation. So my question would be, how then does operational and functional independence affect the perception of independence generally, as regards to the commissions and independent offices? Yes.
Good, thank you. I think apart from the faculty, we have only 2 more, isn't it? From the students, yes.
Yeah.
And the other one is somewhere here. Where are you? No, you are the last, I think. Okay, carry on.
My name is John Koech, 2.2 student. So I'll ask a question with regards to what the current deputy president, I think 2 weeks ago, said concerning public interest and national interest. So we've seen instances whereby the courts emphasize on public participation for the sake of ensuring that public interest is accorded, or that the public interest is accorded the attention it deserves. But recently we've seen an instance whereby politicians are becoming a bit more genius than the public, and they are now bringing in a conversation on national interest because they want to surpass the public interest. So what my question now is, do we really have something of known as national interest that comes above public interest? Thank you.
Very interesting. Public against national interest. Okay, new thinking. I think we had of it recently from the deputy president, the new deputy president. Now we go to faculty. I will start with my colleague, Mr. Justice Mutia, then Mr. P.K. Kamau, and we'll have His Excellency, Professor Kivuza Kibwana, in that order.
Excuse me, sir.
Yes? You had raised up your hand?
Yeah.
Okay, you will come next. Don't worry. You are so determined. Thank you. Yes?
Good afternoon. Thank you, Your Lordship, for the powerful presentation. One of my colleagues was asking me whether it's a defense for, but just a little concern. We have seen, like in the case of the governor for Embu that you mentioned, staying throughout his term at the preserve of the court orders. And of late, there has been this debate about judicial restraint, especially when matters touching on political questions come in. The question in my mind is, at what time does it kick on and at what time does it end? Especially when you have governors being impeached and still being able to stay in office because of court orders. And you also have other impeachment questions that are raised, and they are not saved. There is that restraint, we don't see it kicking in. So my question is, when is it coming in, taking into account now we are not just talking about the political office itself, there is also an issue of human rights that is kicking in that we also need to protect. Thank you.
Thank you, my learned friend. PK.
Thank you, my lady DCJ, and good afternoon, everyone. My question is, it's not really a question, maybe an observation and a question. There is, I see the institutional independence, and we have many independences. I think the reason why the global South has pandered to the West and America has been financial dependence. And now this also comes to us in the judiciary and the institutions that have been mandated to protect the common person. There is a metaphor of slaves, victims, and what, Professor? Slaves, victims, and defenders or something like that. The judiciary is the defender of the common person. Yes, the native, yeah, yes, that is the one. By the way, he's the one who read my name when I graduated in 1993, so thank you very much. Now, sorry, I didn't lose that one. The judiciary has got a fund that was activated. I don't know if it's been activated, the judiciary fund, under the Act of 2016. But when you look at that act, the funds that come to the judiciary come, number one, from the consolidated fund appropriated by Parliament. The next is monies from other sources. That is no pun intended, other sources. Then there is money that is from donations. Actually, when I look at all that, I notice that most of the judiciary's money, apart from also the issue of fines, it shows that the judiciary can use the fines and all, and that would also maybe move the judiciary to increase the fines. But when it comes now to its main source of revenue is the consolidated fund appropriated from Parliament. Now, if we say the judiciary is independent, we know the judiciary, we believe the judiciary has got operational independence, and institutional independence, as you said. But this financial independence is the elephant in the room. What is the judiciary doing? Because recently we heard of Parliament saying we are going to cut the judiciary to size. And what that means is that they won't pass the budget, they will reduce your budget. So what is the judiciary doing? And you being in the Supreme Court, that is where everything is done. And then if they decide to cut your budget, reduce it, does that reduce your financial independence, going down also now to your institutional independence and every other independence, including operational independence, so that you do not depend on these other sources. Let's depend on the taxes that are being increased every day. Thank you very much.
Great. PK, thank you. Your Excellency, Professor. Okay, the student first. Professor is kind enough.
My name is David Mbaluka, and my question was, what?
David Wanduka.
Mbaluka.
David Mbaluka.
Yeah.
From where?
2.2 student.
Okay, go ahead.
My question was, what has the judiciary done to curb the challenges it's facing while defending the Constitution for the past 12 years?
You are supposed to be eloquent enough and concise. Please paraphrase your question.
Okay. In other words, I'm asking that in the past 12 years, the judiciary has faced various challenges. My question is, what steps has it taken to ensure that it does not face the same challenges again?
Do you know any of the challenges? Do you want to discuss any of them? No.
Me? Okay, for one...
As an example.
Yes, I'll give
the Deputy Chief Justice.
Yes, I'll give an example.
For example?
Yeah. When we started, the Dean stated that the ruling given in 2017 encouraged a lot of judges in giving independent rulings and stated that, and then you stated that during that ruling, those who are not happy with it led to the shooting of the Deputy Chief Justice's car. So my question is, what steps have been taken to curb such things from happening?
Or threats and such like intimidative practices?
Yes.
Okay, I think we are coming to the end. Professor will have the final opportunity so that the Deputy Chief Justice can respond to the interjections, questions, and comments.
Excuse me, the final question. My name
Who has given you the opportunity? Oh, Professor. Okay. You missed teaching us by a whisker. I think you had gone for your master's and PhD when we joined, so I respect you.
Okay,
Carry on.
my name is Amolo Pesila. I'm in 2.1. My question is, how is the judiciary engaging with the youth to make sure that they understand how the system works, and also to inspire them to respect the rule of law?
Okay, thank you. Is there any other question which is completely new? Okay, there being no other question now, finally, we have the professor. Thank you.
I'm not sure my students 1.1 asked any questions, and if they didn't, we shall square the matter on Wednesday. Deputy Chief Justice, I wanted to ask, during the recent case on the Public Finance Act, I think 2013, there has been criticism that the standard for public participation was lowered when you compare it with the BBI case, where, and also the BAT case, where there was very eloquent delineation of the elements of public participation. Is this just mere criticism, or was there, some variance in terms of what Article 10 talks about, as well as other articles about public participation? There is a nuance in the Constitution where the EACC is not directly in chapter 15, but in Article 79 of the Constitution, it is indicated that it is also a chapter 15 Constitution. Would that be something that makes it perhaps sometimes not be as robust as the very clearly identified chapter 15 constitutions? The AG used to be an independent office, but now the AG is not an independent office. Does that minimize the ability of the Attorney General to really advise the government robustly on legal matters, or can something be done even in the way in which the AG's position is in the Constitution to make them, to make him or her advise the government in a very robust way? And when, whether it's executive, whoever does not obey court orders, what is to be done? There is an outstanding court order, judgment on the gender, the two-thirds gender principle, and other situations where court orders are not obeyed. What should be done and what is normally done? And of course, when people want to criticize you, they say that you're also corrupt. That is the judiciary. What is it that you do so that it is clear that any issues of corruption are dealt with, so that that charge does not stick? But finally, really, the way in which you took us through the jurisprudence in terms of devolution, constitutional commissions, and independent offices, pinpointing the law, pinpointing the principles that are used to make decisions, I think it is really excellent, and we are richer. We are richer for this conversation. And as I'd asked you, we would like, this material, so that we make it available to our students, so that if my students don't do well in the exam, they have to blame themselves. Asante sana.
Thank you so much, Professor, for that recap interaction. And it is my very great pleasure to request the Deputy Chief Justice to come forward and comment or discuss those questions. Thank you. Welcome.
Let's see. Firstly, no, it was not a defense. We are defending nothing. The topic has told you that we are reflecting. We want to know what this court has done as regards devolution and independent commissions and those two independent officers. When you want us to defend ourselves on anything, please place the charge and we shall respond. Like Mwalimu has asked me, perhaps the most important question today about these allegations of corruption. I will deal with this session as follows. Mwalimu Musao asked about or commented as to whether there is the possibility of devolution having devolved corruption to the counties. You know, you're talking to a judge, and I deal with facts. We have had all manner of allegations, and we have seen what we have seen, heard what we have heard. Now, I will answer to specific questions when they are raised, and my answer, my being or judges, answer will depend on the facts of the case, the evidence of the matter. From that, we shall draw a conclusion, which is called a judgment in our case. And don't think that this is a defense, but if you should think so, you are entitled to think what you want. You know, sometimes it's difficult for a judge to say specifically that this is it. What if that case comes before us tomorrow? Then I shall be dealing with the recusal that our learning brother was talking about. So the less I say about devolvement of corruption to the counties, only because I'm a judge, the better for me. So that in the event that the matter comes for discussion before the courts, and that's the kind of case, by the way, which could rise up to the court where I sit. Alex, you want to know whether that bill that was introduced the other day about IEBC and other things, now that is a perfect case where I cannot give you my opinion. I'll tell you why. One, because it is not in the place of a judge, and I said it in my presentation, to stop parliamentary process. The legislative process must go on. I make no apologies. I stammer quite a bit, but if God didn't want me to stammer, then he would have built me differently, so just bear with my stammering. If a judge attempts to interfere with the legislative process of a legislative body, they will be overstepping their mandate. I said that already, didn't I? So, first, let Parliament do what it does. Once they are done, if an active citizen wants to bring that matter for judicial interpretation, then it will enter the system from the High Court, and by the time it reaches the court where I sit, it will have received various interpretation, and by God's grace, if it reaches the Supreme Court, then we will have the final word on it. Allow me not to say anything on that particular matter for the reasons I have given, that I may have to recuse myself when the matter, if the matter gets here. Done. Separation of powers. Who watches the watchdog? Where the watchdog is the judiciary? You do. The people of Kenya do. Everybody watches over the judiciary. If Parliament does something unconstitutional in lawmaking, the judiciary corrects them. If the executive also, like they do most of the time, makes outreaches and goes beyond their constitutional limits, the judiciary stops them. So who stops the judiciary? The people of Kenya stop the judiciary. And we start with what the Constitution said you must do with your judiciary. And it says in Article 172, I think it creates the Judicial Service Commission and says where the judiciary, meaning staff, judicial officers, and judges do not do the right thing, you go to the Judicial Service Commission, and you go to the Judicial Service Commission with evidence. I see these days, we can also go to the judges through social media. I don't know how helpful that is, because I do not know whether it has an effective result. The judiciary is not above the law. No organ of government is above the law. And so you, the Kenyan, whose authority you have donated to the judiciary to exercise, if your authority is not exercised in the manner you have said it must be exercised, which is judiciously, in accordance with the law and the Constitution, then collect your evidence and take it to the Judicial Service Commission. Judicial Service Commission has removed wayward officers, staff, judicial officers, and judges. And where a Kenyan is hurt by the judiciary and they put their evidence together, due process would require that you take the matter before the Judicial Service Commission and discuss your complaints against the judge. The Judicial Service has a code of conduct to which each one of us has signed. If any judge, magistrate, or staff is in conflict with any provision there, if any member of staff, judicial officer, or judge violates the Constitution or the law, please carry the evidence to the Judicial Service Commission. That is the body mandated with the authority to discipline those that work in the judiciary and to get out of them accountability to the people for the actions they take and for the big salaries they draw. What is the other way of dealing with the watchdog? I don't know it. We give an account, as required by the Constitution, of our performance once a year. And it is a public engagement. Thankfully, the Constitution has decided that we shall be civilized We will deal with issues in the manner that the Constitution says we do. And I want to conclude this aspect by saying mere allegations do not suffice, and no judge or magistrate or a member of staff of the judiciary is above the law. Where we have evidence of wrongdoing, let's pursue it and let's get those who are doing wrong things to be corrected. Public lynching, I don't know what result it would have, but it would most definitely not correct the problem. Those of us who are in this country in the first purge, there have been many purges actually. The people of Kenya got tired and said, this judiciary, let all of them go home, including during the time we were discussing this constitution. Judges were supposed to reapply, and so were magistrates. Along the way, and during the discussions, it was decided, no, let them stay, but they'll be vetted when they are inside. Before that vetting, post the 2010 Constitution, there was something called surgery. In 2003, much earlier, I think. And in that one, even that, although people got their names thrown out there before charges were brought to them, thereafter, a process ensued where you fought if you thought you were wrongly named. The judiciary is not above the law. Any judge, magistrate, or staff who violates this constitution or violates the code of conduct is subject to action by the Judicial Service Commission, which is a Chapter 15 commission. The question, in fact, should be, then who watches over the commission? But we have answered that question, haven't we? We have said where they go wrong, they come back to the judiciary for remedy, and a judge is a citizen of this country. And they have access to the courts as well. When a judge is recommended for removal by a tribunal, in fact, that's a unique tribunal. It is the only one whose decision is appellable to the Supreme Court direct. The constitutionalism we talk about is the totality of this document. And so anything done or not done or not correctly done in accordance with this constitution is subject to test. Okay, you want to know in advisory opinions, when we refer the matter to the Attorney General for his opinion, what happens after the Attorney General has given their opinion? First, let me tell you, if you come to us before you get that advice from the Attorney General, the court has no jurisdiction to hear you because you have skipped an important step in the hearing of the matter, and so we return you to the Attorney General sometimes. And if you keep insisting, as a few people have done, we'll just strike out the matter because we have no jurisdiction. But until the Attorney General, and it is in the same spirit in this Constitution, can we talk? Can we try to resolve issues before we bring them to court? Get the advice. But should you not agree with the advice of the Attorney General, you are not stopped from still accessing the court. You will come and say in court, and they say that all the time. That's why you still see all those opinions, advisory opinions, the AG said this, but we don't agree this is the position. And so that time the court then is closed with jurisdiction, it will hear the matter. But you have to move if you disagree with the advice by the Attorney General. What is the place of interlocutory orders in the impeachment process? Seeing we are saying that we exercise judicial restraint. The judiciary will not stop Parliament from legislating. It can't, it shouldn't, and it has decided that. The judiciary will not stop county governments from carrying out their impeachment processes of their governors, speakers, and everything. It will not. What it will do is that it will uphold the safeguards given in this constitution, and more particularly the safeguards in Chapter 4. If one comes to court and says, you know, I wasn't heard. I'll start there for obvious reasons. Those of you who are alert know why I'm saying that. Then we will hear whether, in fact, the proceeding of the impeachment process is not itself a furtherance of a violation of the Constitution. And if that is given, whereas we cannot stop the process of impeachment, we will say, please proceed, but within the confines of the law and what the Constitution says. Buki, you want to know revenue allocation, compliance with the equitable distribution of revenue, and so on. Now, all of us know the state of the economy at any given time. What I don't know is what they do in Parliament when they are sharing revenue. The Constitution is clear about what is to be done. The Act itself is clear. It says this percentage, this whatever. But whatever happens in between there, that is the reason why I cited, I think, 3 of those matters that eventually end up with us. And when they do, then we see whether the law and the Constitution were complied with. If they were not, you know what we have done. Sirwanga, you have just succeeded in ruining my day. You say that the public has lost confidence in the judiciary. I don't know what your data is, but if that is true, then it is a sad situation. When that statement was last made in 2007, we nearly banned this country. We almost did. Because following an election, thankfully that was pre-2010 constitution. But following a general election, the losers, or the declared losers, refused to go to court because they had no confidence in the courts. Right now, would we say the same? They said that then and gave their reasons. But what is the alternative to not having faith in the judiciary? What we did in 2007, 2008? What is the degree that would allow our loss of faith in the judiciary. And after the 2010 Constitution, don't we have enough safeguards? Haven't we discussed some of them here? And have I not just given you some remedies? No one is above the law. And so if it is a particular judge that consistently does the wrong thing, if there is evidence of wrongdoing to the point of the public losing confidence in them, that must be tackled, and tackled quickly and effectively. I hear you say, survey. I hear you talking about state capture. Sometimes I don't know whether we know that we can actually ruin ourselves by being reckless. If there is evidence of state capture, the thing to do is to bring out that evidence. And since state capture, who is state? The three of them, or is it the executive? Let's use the executive. Mwalimu was telling me as we were sitting there that, Professor Kibwana, that there was a time in this country that the executive had its way. And you didn't do nothing about it. You couldn't do anything about it. Because the executive wanted this judgment, they got that judgment. Can you say that today, surely? Of the current judiciary? Hasn't this government and the previous ones, have they not lost enough cases? Nobody takes a case to court that they don't want to win in, unless, of course, you are a crook and you're buying time or hiding under the legal system. Haven't these governments lost enough cases? But, take this from me. If you should have evidence of state capture, because not all of us, not the 200 of us in the judiciary would be described as having been state captured, then whoever you know has been state captured, let's deal with them. And how do we deal with them? State capture is not a good thing. It kills institutions. It kills what we have discussed this morning for 1.5 hours. We have just spoken about separation of powers. We have spoken about independence and interdependence. It's a further question. And we'll deal with it. And I think we've already dealt with it because we've already said, let it be constructive. You're not a silo. You couldn't do everything on your own. But if you must consult the others, it has got to be within the four corners of this document, nowhere else. Within the four corners of the law, it is not that benchmarking of, sijui kina nani have gone to, where was that famous place? Governor, you ought to know, you were always there. Singapore and other places like that. Oh, sorry, Professor. But should there be evidence? By the way, a judiciary that allows itself to be state captured has lost the authority to be a judiciary. And I'll be talking about independence as Mwalimu saw it, the financial aspect of it, but more importantly, the decisional independence. If in 2024, December, we can actually say we have no faith in this judiciary, that is disturbing. And I can give you a chain of judgments that we have given as a court, from the High Court to the court. You give that judgment, and when you go home, you're sleeping there and you're saying, thank God I'm in Kenya because they would come for me tonight. but let's see how we feel at the end of this session. Yvonne, you want to know the impeachment process of governors? You say, oh, we are restraining ourselves or whatever, or are we waiting for, or is it a tool for bargaining? I would be unable to answer that question. If it is a tool for bargaining, then it must start from where it starts, which is at the county assembly. Is that where they are bargaining? Is it at the Senate? Is it then at the judicial? I wouldn't know. What I know is that there ought to be grounds for impeachment, and they are given in this instrument here and in the law. If one goes to court, then they must have grounds to say, this my impeachment is kaput, and it is kaput because there was violation of the following. If the High Court does not agree, the Court of Appeal might agree, or the Supreme Court might agree. If the three courts don't agree, is it bargaining? Or is it the facts of the case? Is it the law? Is it the circumstances? Let me leave that to our honest thoughts. Vanessa, Vanessa, you want to know when it is judicial restraint and when it is judicial activism. To help me answer this question, Vanessa, would you please tell me what judicial activism is? Vanessa, where are you? Anybody in this class is Vanessa. What is judicial activism? Yes?
It's basically when the court...
It is?
It's basically when the court is deciding cases with regard to constitutional questions regarding politics.
That's what judicial activism is. Anybody else? What is judicial activism? I was actually asked that question at my interview to the Court of Appeal. But what is judicial activism? These teachers will tell me what judicial activism is. Restraint, I think, is understood. And if it wasn't understood before I came here this morning, it has been understood that you will not throw your nose in matters where you are not needed by the Constitution. But I want to be told what judicial activism is, and particularly in relation to this document called the 2010 Constitution. Any teacher who wants to tell me what judicial activism is? Because I know one man in this room who knows what judicial activism is, and it is Professor Kibwana. Because he has spoken to us about it several times. But I won't ask him to answer the question because he's not a student. He will teach you guys if he hasn't done that already. But you who asked me the question, please tell me what activism is. This document, this charter, is itself activist. It left foolishness in the old Constitution. This is neither positivist nor any of those other things you say. This requires you to think every time you are talking about the Constitution, every time you're talking about the law. So what is activism? If activism is doing the right thing within the Constitution and broadening constitutional interpretations, yes, the judiciary is guilty of activism. If that's what activism is. Thankfully, it is not. Because activism is not being one-track minded. Activism is broadening this document. It is understanding the law, the Constitution, and interpreting it. It's a social charter, this document, interpreting it in the manner that suits the needs of the people of Kenya. That's what this document asks us to do. And when we do that, you want to call it activism, then we are guilty as charged. But if activism means applying the Constitution to its elastic end, then yes. And if we do that, we are obeying this Constitution. And I actually ask you, because of the context in which it's used in this country, I've had a few times to talk to it myself, is wrong. It is misunderstood. Let's take time after this class and read on judicial activism. It's not a foreigner, and it is not a negative norm. It is expanding this law. So when do you decide restraint? When do you decide? It's clear. The restraint is, please don't do things whose time has not yet come for you to do at that particular. The time always comes. If it's legislation, let them finish, then we will contest it. If it is impeachment and all the rules in the book are being followed, then let it be finished. Then you will come and tell us, I was wrongly impeached. Because the reasons given, look at their evidence. Only a fool would have accepted this kind of thing. Restraint is do your thing at the time you are supposed to do it. And if you are not supposed to do it at all, please stay away from it. Then give it its literal interpretation. Recusal of the apex, quote from a famous case. What happens if there is an appeal? I know the case you're talking about. The Judicial Code of Conduct tells you when you will recuse yourself from a case. The most critical ground is conflict. For any reason you are conflicted, and therefore your decision will be tainted. In the case in question, we were actually asked not to hear that case because we were taken to the Judicial Service Commission. And so the appellant said this, in fact, they even went further and quoted judges who are not even in the matter, and said, we don't want these judges hearing this case because, I don't know what the because was, but we were asked not to hear the case. And we obeyed. If you come to me and say, I don't want you to hear my case for the following reasons, and the reasons are valid, there are times a judge will be asked to recuse and they will refuse to recuse if the grounds for recusal are not proven. But we all say there's no property in a case. It's not personal. So if a party doesn't want you hearing their case, they will be heard by the next judge. But in the Supreme Court, there is only 7 of us. At any given time, quorum is 5, so 5 of us must sit at once. In complex cases, we sit all 7. So if you come and tell us, because I've taken you to JSC, don't hear my case, then we will wait for you to finish with JSC, then come back. And when you come back, if we will still be here, We'll decide at that time whether we should hear you or not. Are there good lawyers who, yes, and first of all, Martin told you the right thing, Conless. I hope I'm following this list properly. Who told you to choose law? Now, once you choose law, you never stop reading. And if you stop reading, then you are no longer a lawyer. Because this profession of ours is you read all the time. Whether in answer to a specific case or just reading generally, because our law is like this. You really can't say, oh, I'm a constitutional lawyer, so that's where I will stay. What if an aspect of contract will arise in between there? You must be well-read as an advocate, so you are always reading, including reading those novels. Are there good lawyers who have read and read? So when they come to court, I have a difficulty in finding out which one has won. I don't think so. Cases are not always won. They are sometimes won because of the brilliance of a lawyer, but I'll tell you that that is not the correct position. Cases will be determined on their unique circumstances, their facts, and the law that relates to that case. So whereas a good advocate, and by the way, I have seen some very good ones who have defended a dead case, or what I thought was actually a dead case before I walked into court, and I'm saying, Goja, let me listen kidogo to this guy. What is he saying? But at the end, the facts of that case, the law, and the evidence will determine which way to go. It's very good to be a very good lawyer. Because first, you grow jurisprudence, you help the court. That's why counsel exists. Counsel exists to present all the facts of the case before the court in the best possible manner. I had Mwalimu Musau telling us in the beginning, when you ask questions, mukwe respectful. In law, in our here, we call it what? You said it. Decorum. Now, if you come before a judge, and because you think you're very good, you are insulting them. Last time I checked, judges were human. Last time I checked, these judges went to school with these lawyers. Last time I checked, we think we all know each other. Let's stay with the case, bring the facts of the case, place the law, the constitution, the evidence within the case. Now, if you're very brilliant, and you think you might confuse a judge, let me tell you what judges do, or at least majority of them. I know it. Judges read. Judges have no life, it's reading. But it is good to be a good lawyer. Whether or not you will win a case because you're a good lawyer, you have no excuse but to be a good lawyer. You must be well-read and then learn how to present your cases. There is a reason it is called pleading the case before the court. And whereas nobody is asking you to worship a judge or a judicial officer, please plead the case. It is the rule. Just be decent. Have decorum before the court and let the chips fall where they must. Coach, you want to know, no Abigail before you. Operational independence, no detachment. What we discussed this morning was we all must keep talking to each other. We are interdependent. No arm of government, no institution can survive in a silo and actually successfully do so. None. Parliament appropriates our money in the judiciary, so if when we appear before them we are full of nonsense, and we are not telling them our needs appropriately, do you think we will be heard? Yet, it is what this charter says we must do. But I'm reminded of an African saying, last I saw of it, it was in Things Fall Apart, and it said, an African does not refuse to be called. They may refuse what they are being called for, but you will not refuse to be called. So now, if you are invited by a fellow commission or by parliament, you know where it comes from, our Watu, they were being summoned, or they take a detour and go this other side. If you are invited for consultation, because you are interdependent with that other organ, please go, discuss. You may not agree, even in that mediation, go, and the law has provided a way out. If you don't agree, you will come back to the court. Coach, public interest. I know what we have said. In fact, maybe I answer you at the same time I am answering or reacting to what Professor Kifuda said about what we are doing with public participation. Public interest, ngoja, it may find it, in fact, you can be sure it is coming to the Supreme Court. Because in this country, kakitu kanaanza hivi tu kidogo, the next day there is a big case. And I have had that discussion, not from the Deputy President alone. I have heard it over radio discussions. They are called what? TV, those morning shows. I have heard it among us. There is public interest. Then there is. Let's see where we go with it. Oh yeah, then I was asked whether what I was doing was a defense. Far from it. The political question, judicial restraint. Let's just deal with court orders, because I think I've said enough about the rest. And governors staying in office, to my knowledge, it was just that one. And by the way, Najua, it was early days. We were just beginning the process of dealing with these matters. But let me say this about the length of cases in courts. Quite apart from the fact that a person who is affected by something will want to go to the High Court, go to the Court of Appeal, and if there's a route to the Supreme Court, they'll want to go. Quite apart from that fact, there is law in this country which, a lot of it actually, says if a matter is not determined within this kind of time, it is bad. And I think let's just start at the Limitation of Causes Act. Everything there has a date. Kama ni taught against or by government, you take your 1 year. Kama ni mashamba, 6 years. Kama ni contract, kawaida 3 years, and so on and so forth. Then we came to the 2010 Constitution, and there we went to the political issues, elections. We were hearing election petitions for 5 years. And the term of parliament is how many years? What is the term of an MP? 5. You see, cases belong to the parties. And although, and I keep saying this to ourselves, although we judges and magistrates ought to have complete control of the court, our counterparts, the parties and the advocates, if they want a matter delayed, unless the official hearing that matter is firm, that matter will be delayed. But if, as it must happen, the the judicial officer is firm, what the law allows us to do is determine matters expeditiously is the word used here and in nearly everywhere else. Within reasonable time is the other term. But let's talk about time. If the presidential election petition, which used to again also take the whole 5 years or close there, although most of those ones were struck out for reasons Professor Kivuda will give you after I have left. If since 2010 we do the election, the presidential election contest in 14 days, it is because that time frame is here. For all these other matters which time is not given, and it says within reasonable time, it also depends on what is reasonable time. Expeditiously, it also depends on expeditiously. Is there a way that we can actually hear certain cases on a day-to-day basis? My answer has forever been yes. Whether or not the law says do it within 14 days. The nature of certain cases must be must be resolved quickly. Quickly. But if the law doesn't give 14 days as it does in the election petition, what are you to do? The Chief Justice has no power, not one given by the Constitution at any rate, to tell a judge, finish this case haraka. In fact, if they do that, the judge says you are interfering with my independence. But nothing stops the Chief Justice from telling judges to do their work and do it in the manner that is expected of them by the Constitution. But I'll tell you this, maybe we don't have enough numbers in the judiciary of judicial officers and judges so that we could hear cases on a day-to-day basis, maybe. Actually, that one is not a maybe because I know the answer is that we are not enough. And whereas we are hearing matters virtually and all manner of, we are also losing a bit of value in the evidence we get, particularly in criminal cases, because if you're sitting there and I'm sitting here, demeanor is lost. But should the judiciary now of itself sit down and determine that certain nature of cases ought to be heard as quickly as possible? I think the answer is yes, but as soon as we take a judge away and say, you will hear this case on a day-to-day basis until it is over, we have to determine what is the nature of that case. And as they are doing that, remember, all these other ones which are part heard, Nusu, 5 witnesses heard today, then we put a case for, they will wait. Then we put a case for day-to-day hearing. I know it can be done myself. Sitting where I do, I know it can be done, with consequences, of course. But I said it takes two to tango. Then the witnesses are not brought, then appeals, you strike it out, this and the other, but something has to be done and it has to start, and start now if you ask me. Financial independence, the judiciary fund, and so on and so forth. Other sources. I tell you, one of the things I have not enjoyed sitting where I do at the moment is having to go to donors to ask them to chip in. Yes, the judiciary fund was established by this constitution. I think it is someplace at 170, or is it 170 or 70 something? 73, 75, what is the judiciary fund. Now, that fund gets money from the consolidated fund. Last I checked, and I check fairly often, this country does not enough money, does not have, well, we are told there is not enough money to go through everything. So the fund, when we are dealing with the budgeting process, we go to Parliament, we defend. Right now we are going round and asking views from the public as to what they think should be our budget. Once we have done that, we go to Parliament for appropriation, and then the Treasury gives us. Not once has the fund ever been inputted with the total amount of the budget. And the reasons are known to us. There's not enough money to go around. But let me answer the question directly. It is when the financial independence is interfered with, are we going to succumb? And will it affect decisional independence? It shouldn't. In fact, if you joke, it ought to have the opposite effect. If you are not paying me and I'm working for you fully, you should be worried. I think you should be. But you know, I've been a judge myself now for a very long time. Every month my salary has been paid. But is it about my salary? Do the vehicles have fuel to take judicial officers for mobile courts? Do we have enough courtrooms, for instance? And we are still hearing a lot of things in courtrooms. Do we have enough money to pay the staff? Because their money does not come from the consolidated fund. The judges' salaries do. The magistrates, do we have enough money to pay those magistrates? Okay. Can you operate optimally without finances? I think the answer is no. Is financial independence important? Critically so. When you don't have it, should it affect your decision on independence? I shouldn't think so. But if it should, I think you should be worried. But Luka, you want to know these threats, intimidation. I think I better not answer that question. I know what I went through in 2017. But I'll tell you this. If a judicial officer is so cowardly that they cannot do the right thing by the book, then they shouldn't be judicial officers. That much I will tell you. The consequences, unfortunately, are personal to the judicial officer, to their families, to the people who love them. But a judicial officer must obey the oath of office that they took before they started discharging their duty, and that must be that they will hear all cases, whether they are against the state or against powerful people or against who, irrespective of all these other things you hear, this, that, allegations, left, right, and center. But a judicial officer or does not have the courage to determine a matter in the manner the Constitution, the law, and the evidence says they should do it, shouldn't be here. Question of fear should not exist in the mind of a judge. But are we afraid sometimes? The answer is yes. You should ask me what I was feeling that time after my car was shot at. And to this day, sometimes I wake up and shake and say, suppose I was in that car. Suppose I was inside. The judiciary fund is in Article 173. Threats, intimidation, if they come directly, of course, there are corrective actions to do. You go tell JSC, I'm threatened. You tell the DC, what are they called? Those policemen who are called as security. Many times judges have come and said, I want my security increased. This case I'm doing is sensitive, and we have always facilitated. I do not know whether having too many policemen around one is a sign of security. Priscilla, what is the judiciary doing about the youth? Thankfully, lately, first we started with the moot courts, you saw that. Secondly, this is the other one. We will be talking to you from now going for as long as Maurice and like-minded people invite us, we will be engaging with you. You come, you are always in the courts, by the way. If Daystar doesn't do that, you have my invite now. You are always coming to the courts. I'm always talking to youngsters, even from high school. They ask us, how does the judiciary work? We take them through sessions. You book, and we are there waiting for you. And we answer your questions. And we listen to your suggestions so that we can improve both you and us. Now, if a country that doesn't care about its youth is dead, because really, where will we be without you tomorrow? We are old now, we are getting out. Nyinyi ndio mnakuja ku take over. Will you take over if you are not sufficiently enabled? So we are here for you, you come. In fact, the Chief Justice started a mentoring a process with young people. And they come around and we are called and we talk to them outside there. And finally, Professor Kibuda Kibwana. Have we diluted public participation in the last decision of the Finance Act? Would we actually dilute a decision we have made without definitely saying we depart? The Supreme Court is the one court which has power to determine that the case we decided yesterday, I don't know on what basis we decided it, we think it is bad law, we've forgotten it, this is the way we will do it. The Supreme Court, I think it is somewhere in Article 163(7) or thereabouts. We are not bound by our decisions, and we can revisit or revisit in the meaning of 2024, not in the meaning of 2017, and correct that which we find to be wrong now. I don't think, I think somebody needs to read the judgment on the Finance Act 2013 with an open mind. Not saying the judiciary is captured. Because if that is the mind frame with which you start reading this, that is what you will find. We did not depart from BAT in that judgment, and we did not definitely depart from BBI on public participation. But listen, public participation must have an end. It's not a vicious cycle. Ati come today, go tomorrow, come again. Tutamaliza when? And we explained ourselves clearly in the no. So, Professor, I do not think we diluted what Article 10 requires us to do, not what we said in BAT and not what we said in BBI. The Office of the Attorney General. First, let's deal with the ESCC. You know, ESCC is an extremely powerful body, and I have heard they are cushioned against a lot of things so that they are not tempted, because the kind of cases that go there are not nice cases. If they be not robust, because they do not have the protections in Chapter 15 commissions, yet actually the Constitution says they are there under this Article 79, then I would attribute that to the personal character of the personal officers at a given time. I have just said here, I'll repeat, if you take an oath to do something, and then you are guided by factors of fear, favor, and other things, just put down the oath and leave. Because then you don't have the character to stick. But human nature is what it is. And once their issues are raised, if there be any, as to do they chicken out on certain matters, the way you were framing the issue, I don't know. And if they do, they should be thrown out of office. They are not immune. And there is a process of their removal as well. The Attorney General is no longer an independent office, as this watered down its. Let me just say this. I haven't worked for the executive, but if I was an Attorney General and my opinion was sought on an issue, I would say what the law or the Constitution says should be done. What is done thereafter, I do not know, because an Attorney General holding that high office must surely give the correct advice. And the good thing with the Attorneys General is that they have a big office, they have researchers, they have all manner of people. Nobody, by the way, knows everything, including all these other ones who keep insulting us every day. Nobody knows everything. So you get your people to do research, put it together, assess it. Finally, remember, you are the one putting your signature on the dotted line. Before you put your signature there, ensure that what you are saying is constitutional, it will stand the test of time because it's legal and all that, and then the rest. Questions of politics, Professor, don't ask me. I am least qualified. I can't answer those ones. But I think that, first, am I losing the point? Is that office important? Very. Should that office have some cushion so that whatever it is you give, whether it is taken or not, is not returned to you? I should think so. Should the people, what is the qualification to be Attorney General? How do you, and those Attorneys General will be human beings, right? So they will consider all these things I've been talking about, judges and other people, and determine, can I handle this job? If it becomes too hard to handle, I think there are options. The first one is to resign. Obedience of court orders. What should be done? I even can't believe that, Professor, you asked me this question. No one is above the law. Court orders are not suggestions, they are for being obeyed. And where there is no obedience, and there is a route to a consequence, the consequence should be taken. And if, this is my view, if you are too big and we can't execute against you, as we cannot against government in a lot of instances, then let me take time. And it is a blot on yourself. Anyone who does not respect a court order is not to be described in very favorable terms. So at some stage, the fact that you didn't obey court orders will have somebody think something about you. I doubt it will be nice. This judiciary is also accused of being corrupt. What are we to do? I have heard, and I live in this country, I'm a senior citizen, And I think it would be not being truthful to say corruption is not a problem in this country, because I think it is. We have had statements like because we are always accused of being corrupt, saying that is not enough, and you know it better than I do. So what I would urge, and I have said this, in fact, I have said it so many times, because it's painful, by the way, to continuously be told you are corrupt. If you are a normal human being, it will hurt, it must hurt. So where is the evidence? Where there is evidence, and I am sure there is evidence somewhere, because unless you are a lunatic and you just stand there and just start bashing anyone, where there is evidence that this judicial officer, the first one is bribery, is taking bribes so that they rule differently, honestly, I think that should be brought forward and actioned immediately. Whoever the person against whom the allegation of corruption is, whoever, just bring the evidence. But the fact that you see me driving a big car here is of itself not conclusive evidence that that is corruption. But should it be, just bring the evidence. So I think the judiciary ought to be susceptible to scrutiny, to open themselves out there, bring the evidence. Let us be taken down the guillotine, take us to JSC, take us everywhere else, show the evidence that what are you talking about? This dress you're even wearing, I know the person who bought it for you, and I know the case, and it is this one, and this is, let's do that. It is the only way we can clean this rot. There's rot in the judiciary, there's rot in the executive, there's rot in parliament. This is what I hear every day. There's rot in society itself, there's rot everywhere. So let somebody start. I will myself not say, Professor, you are corrupt, unless I have the evidence and come and present it to whoever I must present against you. Anything else could border on other things. We will sure enough give you copies of all the 7 lectures we gave, all the presentations. I'll find out whether you need to pay a little fee, Maurice. All the presentations that were made, we had the international judges here during the conference and everything. The totality of what must help you get better as lawyers, we will give it to you. Thank you very much, Daystar.
I think we have to clap again. Outstanding contribution to jurisprudence. Okay, we may as well now get seated. We have come towards the closing of our today's program. So we have very few remaining activities, and I beg that we all participate towards the end, very few minutes. So after my very short comments, we will request the Dean to make a presentation to the Deputy Chief Justice, who is our chief guest today. Then I will ask PK, my learned friend and fellow lecturer, to move the vote of thanks. Then we'll ask the chaplain to close, and thereafter we will have the photo session. So I will come back to guide you on the photo session. And just before the Dean comes over, very briefly, we are very grateful for your Lordship's contribution to jurisprudence on devolution, constitutional commissions, and independent offices. I know PK will move a great vote of thanks, and I'm not preempting his comments. And I have no doubt that what you have given us today will contribute greatly to the ongoing discourse on empowering local governance and public service, enhancement of public service delivery under the Constitution, and the role of the judiciary in supporting the framework in that context. And I recall very well that, as you have discussed, devolution, and this is what we have been teaching in legal theory, and the professor is here, in Kenya is actually the decentralization that we have discussed in depth. And we have also been discussing in legal theory, and the students, please take note, that while we have the executive and the legislature manifesting themselves through devolution at the national and the county levels, the judicial arm and the constitutional commissions as well as the independent offices are not yet devolved. So maybe in our next discourse, Your Lordship, it will be very important to discuss the possible devolution of the judicial arm of government as well as this debatable fourth arm of government. And in this context, I would like to request the Dean to please do the presentation. You can bring the mic. I don't know whether you want to come to the front. Yes, I think it's good. Or just here. Yes, please bring the mic. Please bring the mic quickly. And the camera persons. Okay, Professor Dean.
Thank you very much. This is in appreciation to the Deputy Chief Justice and the Vice President of the Supreme Court for finding time and gracing this occasion and sharing with us a lot of words of wisdom. So we thank you very much.
Thank you so much. Let us clap. Let us appreciate the Deputy Chief Justice and the Dean. Let us appreciate them. Okay, thank you so much. I will then ask my learned friend and fellow lecturer, Mr. Paul Kamau, to please come forward and move the vote of thanks on behalf of Daystar. Thank you.
Thank you very much, Dr. Musau and everyone. I intend to take less than 3 minutes. And the period I'm taking, the time I'm taking does not diminish the thanks that I'm giving. First of all, I would like us to thank the Almighty God for this opportunity that is given to us and allowing the DCJ to grace this occasion. We are grateful to God that He's allowed you to do that. And we are grateful that you honored this invitation. We were a bit worried when you didn't come the first time, but now we are happy that you become the friend of this university. And more so the law school. This is a place where future servant leaders and servant lawyers are being made. We have quite a few coming out, and we shall be glad to see them come to the admission called to the bar by your colleagues and yourself. I know that you are still there, and the Lord will bless you all. Now, we are grateful also for the wonderful presentation you've made. It was great. And I want to disabuse something that my friend and fellow lecturer, Mr. Mutia, said. He did not mean you are defending yourself. He was talking about defending a thesis. I think that's, yes, a PhD thesis. That is the one. And he'll pay me for defending him in that one. I want to thank you also, and you'll pass our regards to the Chief Justice and the entire bench for honoring this university to be one of the very few that you are visiting. I also want to thank my fellow lecturers and led by Professor, our own professor and friend. And he said he's no longer Excellency. But once an Excellency, Professor Kivuda, always one. I want to thank all of you colleagues for coming. I know that many other people were not here, but we decided to come. It would have been very bad not to be here when our DCJ is here. We are grateful. I want also to thank the students. I know these are very difficult moments for you. You are reading for exams, studying for exams, but you came. Madam DCJ, the reason why there are not as many as you would have expected is because they are reading for exams. There are many who are not here. But we are a big law school, and we thank you students for coming. I want to thank also the chaplaincy. Without you, in fact, I'm the one who insisted, no, we have not prayed. I asked the dean, no, we have not prayed. And thank you, chaplaincy, for being here and gracing this occasion. Corporate affairs, you know, without you guys, we would be looking very bad out there. And we are looking very good at the moment, especially when it comes to the photo session. And then, you know, we can sambaza those photos with the DCJ and say we were here one day. Thank you very much. We appreciate you. We also want to thank all other staff members who are here, because you are here because you love the university, you love the DCJ. You are loved here. And that love may it go around and bring cheer even during this cheerful season of Christmas. We thank you. And allow me finally to thank myself for thanking you. The Lord bless you.
Okay, thank you very much. Let us all appreciate ourselves. So, we will do the photo session, a slight change on the program here because of time, and we think upon consultation with the judiciary is more convenient that we do the photo session here from this podium. So the first photo will be the Deputy Chief Justice, the Dean, and His Excellency Professor Kivuda Kibwana. Those three. So you can come to the front, and I will then control the program from there. We can remove these dais from here, the communication team. I will have the mic from down there. Let me use that. Just the mic alone. Just the mic. In the dais, we are up here? Yeah, up here. The three of you. Remove these as well. This one.
Irudi.
There are about four pictures.
And then the students
will
do it outside there.
No, the students will come here.
These students, so many will not get.
They will fit.